All right. So it's time to begin the conference. So let's get started. Professor Ugo Pagallo, thank you so much for accepting our invitation. And originally, we planned that you'd come to Japan and talk in front of the students of Chiba University. But because of this COVID-19 situation, this lecture was decided to be held online. So I am expecting a lot of students will listen to this lecture through internet. And at first, let me talk about this series of lecture. This lecture is provided by the project Chiba Studies on Global Fair Society. Researchers of law, politics, economics, and sociology joined to this project, and we aim to share interdisciplinary discussions about fairness and justice. One of our plans in the year of 2020 is to research the relationship between the innovative technologies of artificial intelligence and ethics, justice, or fairness. So we started this series of lecture titled, "Is it possible for AI to be fair?" In this lecture series, the first lecturer was Professor Christoph Lütoge from Technical University of Munich. And today, as the second lecturer, we are very pleased to welcome Professor Ugo Pagallo from Turin University. Anyway, unfortunately, nowadays, almost all people in the world truly realized the importance of information technology. Of course, Chiba University provides many lectures through internet now. But how about the legal regulation or the ethics of information technologies? Have we thought or discussed about that issue enough? Not enough at all, in my opinion. The discussion has just started. Of course, we have a sophisticated and long history of the abstract theory of law and ethics. However, we have not finished the project of applying such kind of theory to the practice of innovative technologies such as AI. So today, we would like to learn how should we make a good collaboration between legal theory and legal practice from the lecture of Professor Pagallo. And so before starting, I want to ask our project leader, Professor Mizushima, to make an opening remarks.
Hello, nice to meet you. My name is Jiro Mizushima. Oh, yeah. I'm a political scientist, and Professor Kawase is he's a specialist in the philosophy of law, and we are engaging in joint project about fairness from interdisciplinary approach. Our members include specialists in law, politics, and economics, and sociology. And the main topic is fairness. And now AI would pose us a great challenge on the concept of fairness, because by using AI, probably our concept of liberty, human rights, or equality might change in the future. So I'm very pleased to hear from you about what you think and what you would say about the future of AI and its impact on legal systems. And And I personally, as I said, I'm a specialist on the political science, and my interest is populism. I have written and published books and articles about populism. And in Italy, there are more than one strong populist parties. So now, I hope later I can ask you about it. But anyway, I'm looking forward to hearing from you about your presentation. Thank you very much for joining us. Yeah.
Thank you very much, Professor Mizushima. Now, let me ask the start of the lecture. At first, Professor Pagallo speaks about 1 hour, and after that, I and Associate Professor Nishigai will make some comments and ask some questions. And finally, we will have some free discussions. So, Professor Pagallo, please go ahead.
Thank you very much. It's really a pleasure, a honor to be with you. Unluckily, not physically and personally in your wonderful country. I love Japan. I've been sometimes over there, and I expected to be with you at Chiba University, but well, let's do it next year. And but now let's focus on matters of fairness. As you can see, my presentation is about this very issue. Is it possible for AI to be fair? Let me go straight to the point. I think that it's possible for AI to be fair, but of course, in order to illustrate, to tell you why, I will need 1 hour. As you see, on the one hand, I focus on matters of fairness as a principle of the law. However, as the title of my presentation suggests, we have to pay attention to matters of context dependency, namely the fact that when we are talking about fairness in the legal domain, we have to pay attention to different possible meanings and applications of this principle. For example, talking about legal context dependency, we may think about the fairness in criminal trials. And so we have all the issues regarding a fair trial in the criminal domain. But we can also think about fairness in civil as opposed to the criminal side of the law, fair play in contractual obligations, and so on and so forth. How to tackle then the context dependency of the law? Well, as you'll see, I would suggest to tackle this specific problem in accordance with the stance on legal governance. So, on this basis, I have organized my presentation according to these 5 points. I'll start talking about principles, legal principles. Then the attention will be drawn to the principles of artificial intelligence. Namely, I'll be referring to today's debate on the ethical principles of artificial intelligence. Then finally, we'll focus on matters of legal context dependency and legal governance so as to draw the conclusions of my presentation. So let's start with legal principles, since I assume fairness as a legal principle. Here, we have to pay attention, therefore, to the impact of artificial intelligence on today's human rights frameworks. As you see, I'm showing you the cover of my last book with Professor Woody Barfield, namely The Advanced Introduction to Law and Artificial Intelligence. And the first chapters of this book focus just on how AI may affect today's human rights. Of course, I'm thinking first of all about the Universal Declaration on Human Rights from 1948, or at a regional level, for example, here in Europe, I could consider the 1950 European Convention on Human Rights. And there are several ways in which AI, therefore, may impact on this legal framework. In particular, when we are considering matters of fairness vis-a-vis human rights frameworks and AI technologies, well, as you can see, there are many ways in which we can tackle our first question today, namely, can AI be fair? Well, we should pay attention. This is a well-known list of human rights from the Universal Declaration. We may think about matters of human dignity or equality, or right to life. And you have the list in this slide. And of course, I cannot talk about all these topics. I could, but that means next year I'll be spending a week with you in Japan in order to brainstorming with you all these possible facets on fairness, AI, and generally speaking, human rights. But let me deepen this perspective with a case study, the so-called laws of the horse. Why I think it's fruitful, a step backward, because in a way, we already experienced how technologies may affect the law one generation ago, namely when scholars, experts, started examining how information and communication technologies could affect the law. And this was a debate which occurred, wow, time flies, I was younger, 30 years ago in 1990s. And in particular, I'm referring to a very famous speech by Judge Frank Easterbrook, who argued against the idea of defining cyber law, and for that matter, law and artificial intelligence, as a unique field of legal studies and litigation. And that's why it was funny, let's admit it. Judge Easterbrook talked about cyber law as the law of the horse. In a nutshell, he said, how it's possible to talk about cyber law? It's like preparing a course in our legal departments about the laws of the horse. That is, contracts, how to buy a horse, health system, how to heal a horse, and the like. Of course, several years later, in the context of computing systems, it seems clear, at least to me, that Judge Easterbrook's view was short-sighted. So much so that we have now a vibrant, exciting field of legal research, which is called information and technology law. What happened then 25, 30 years ago? Well, here we have a very interesting test on how technology may impact tenets of the law. In particular, let me compress this point according to only 3 points, but I think these points are very important. First of all, the more we live in an information society, the more the law turns into a matter of access to and control and protection over information in digital environments. Mind, this is the first time ever that human societies depend on information technology laws. Just to give an example, an information technology is writing. Humankind invented writing, nobody knows, but let's say 2.5 millennia ago. So since the very beginning of our societies, human societies have used information technologies. But this is the first time in human history that we depend on these technologies. And it's very important to pay attention how the law is turning into matters of access to and control and protection of information. Examples, think about personal data protection. By the way, we have an agreement between Europe and Japan about the flows of personal data information. Moreover, this agreement between Japan and Europe has set up the largest area of free movement of personal data in the world. Other examples regard cyber crimes, the dark side of the story, and e-commerce and so forth. You got the point. However, this also means that there are no clear boundaries in cyberspace. Of course, compared to 25 years ago, now we have a geolocalization, but still we have several problems of extraterritoriality. For example, the GDPR, the European General Data Protection Regulation, set up very strict norms on extraterritoriality. That is how European laws apply to the rest of the world. And we have several other examples. This is another game changer because of technology. And finally, the normative side of the law has increasingly transferred from the traditional O2, namely the law as a normative science, to what actually is in technical terms. That is, we are embedding legal constraints into technology. And of course, what's happening with AI, and can AI be fair? Well, this is the point. How to embed fairness as a legal concept into the state transition system of an artificial agent. Well, on this basis, as you can see, this is not the first time we are thinking about how technology affects the law. We have 25, 30 years of experience discussing this very topic. But what's unique to AI? Namely, how can AI system affect current legal systems on fairness in criminal trials, fairness in those non-discriminatory practices, fairness in personal data processing? This is what I later examine as the context dependency of the law. But before examining this part of the story, it's crucial to understand what's unique to AI, why AI raises new problems, and of course, in the legal domain, new legal issues. So the second part of my presentation has to do with the principles of artificial intelligence. Here I have to mention, let me say, a very famous paper which we published, I mean, with some friends of mine, Professor Floridi, Professor Folke, and Professor Dictum, a long list of colleagues and friends. This AI for People paper from 2018, 2.5 years ago. And here you have the 5 points that should allow us to understand what's new with artificial intelligence. AI raises new issues concerning human control, namely reducing human control, removing human responsibility, devaluing human skills, eroding human self-determination, enabling human wrongdoing. As you can see, there are several reasons why. First, we may expect AI enriching, improving our lives. However, second, there are many issues, and here you have samples, for which we can be afraid of artificial intelligence, bad uses of these technologies. But third, and this is very important, together with good uses of AI, bad uses of AI, we should pay attention to under uses of AI. That is, we could use AI, for example, in hospitals, but still we are not using this technology as we could. By the way, more on this later, but over the past month, I've been working with the World Health Organization on this specific problem. So I'll return to this issue later. Of course, it's an open issue, how to grasp current discussions on the moral principles of artificial intelligence vis-a-vis in light of work on how to amend today's legal frameworks. That is, it's very interesting. We have this double parallel debate. On the one hand, experts discussing the moral principles of AI. On the other hand, legal scholars discussing about how to amend the law. For example, in this latter case, I've been working with the European Commission over the past 2.5 years, and we presented a report to the European Commission about how to amend that specific domain of the law, which is tort law, extra-contractual responsibility. But how to put together ethics and the law? This is a philosophical nightmare. I won't discuss this. A very famous Italian philosopher from the 20th century, Don Benedetto Croce, used to say that this is the Cape Horn of legal science. You know, Cape Horn is that part of the world in Patagonia where you have storms, the sea is really dangerous. Luckily, I will not discuss about how to put together ethics and the law. Why? Because I'm a lucky guy. Because most of the time, the ethical debate has not to do with how to amend the human rights framework, the fundamental rights framework. It's how to amend secondary legislation, and of course, how to interpret the articles of the Universal Declaration, in Europe, the articles of the European Convention, and the like. But it is complementary rather than a clash, ethics versus the law. No, it's complementary. so that we can focus only on the law. And however, there are two different ways in which we may appreciate this impact. I use some spatial metaphors, namely vertically. Imagine the law as silos. And so we can imagine AI affecting the field of criminal law. That LAW means laws of war. As you know, there is an important discussion in Geneva, Switzerland, about how to amend the Geneva Conventions regulating the laws of war. In other words, can autonomous lethal weapons be considered legal? This is another very hot debate, which is actually discussed by this group of governmental experts for the, in the UN, United Nations slang, the so-called certain conventional weapons system. But then we have problems of tortious liability, extra-contractual liability. I already mentioned my work with the European Commission. Sorry, the acronyms that HLEG means High-Level Expert Group. And by the way, this work has been adopted by the European Commission in the White Book on Artificial Intelligence, which was published last year, a year ago. But we could go on talking about administrative law, contract law, for example, intellectual property rights for artificial intelligence. Can an AI system be an author of a copyrightable work? Can be an inventor? Those are further crucial issues brought forth by AI. Down to problems of legal personhood. Can an AI robot be a legal person? Can be a legal agent? As you know, we already have the first AI citizen. Saudi Arabia, 3 years and a half ago, granted the citizenship to Sophia the robot. Okay, you can, but even the United Nations granted Sophia the robot a special mention. What's going on here? Well, these are different facets on how artificial intelligence may affect criminal law, civil law, tortious law, administrative law. But this is only one side of the story. Then we can examine this legal impact horizontally, so to speak. That is, we can examine how AI may affect data protection rules, regardless of whether we are considering the criminal law, the civil law, the administrative law. This is why I talk about a horizontal impact concerning data protection, surveillance law, communications law, and the like. So that we have really several different possible topics today. Let me go back to the previous slide just to give you a concrete example. I'm not kidding. We could spend 1 week together discussing, and I hope next year we're gonna have this opportunity. But let's consider the criminal law field, just to give you an example on fairness, namely criminal fair trial. What's going on with AI has to do with the fact that AI is often used for collecting criminal evidence, so that prosecutors will present proofs that have been collected by the AI system. In several cases already, defendants, that is, people under trial, have asked to examine, to inspect the code of the algorithm of this system. We already had in United States a very famous case, the so-called Loomis versus Michigan case, in which the court declared that Loomis' lawyer had no right to inspect the AI system. Why? Because protected by trade secret. And even the judge couldn't have a look at the code, the algorithm of the system because of trade secret systems. To say the least, I see it as something unfair. But also in Europe, we are close to have similar problems. Why? For different reasons. That is, also in Europe, of course, we have the principle of fair trial, which is Article 6 of the European Convention on Human Rights. However, the European Court of Human Rights have so far interpreted this principle of fair trial subordinated to Article 8, namely the right to privacy, which means you may raise problems of fairness in a criminal trial only if you prove that your right to privacy, your data, has been violated. But with AI, we'll have several cases in which the fairness of a criminal trial is irrespective of matters of privacy and personal data protection. So, as you can see, AI really raises crucial issues on fairness. I gave you an example on fair criminal trial. Further examples could be on fairness and non-discrimination, fairness in contracts. But this raises the further issue, namely the context dependency of the law. In other words, when we are talking about fairness, of course, we have a general principle, but then we have to make this principle specific in light of the legal domain we are taking into account. Again, fairness and criminal law, fairness and contracts, fairness, and especially here in Italy, public administration, fairness and taxation. You got it. So, another crucial point when we talk about AI and legal regulations is that not experts, but common people think that there are no legal regulations for AI. This is a mistake. Maybe the laws we have are not good enough to govern AI, but still we have a number of laws which are already applicable to AI. Moreover, these laws are often context dependent. In other words, we have a multitude of rules regulating AI in the fields of self-driving cars, drones, e-health, financial services, data protection, and the like. So, my problem, so to speak here, is how to put all these different legal domains together. For example, this is my favorite example because I started working on drones, namely unmanned aircraft systems, again, with the European Commission since the very beginning, 10 years ago. And on the other hand, my other passion has to do with autonomous vehicles, self-driving cars. You may say, hey, okay, this is AI for both old airplanes and good old cars. You are the champions of the automotive sector. By the way, in my work on the laws of wars, I stressed that Japan took a strategic advantage in the automobile sector because you were the first using robots in the automobile sector. However, even if we are talking about AI for drones or AI for autonomous vehicles, in legal terms, you have two different words. Not only Europe, I'm not expert of Japanese law here, but I suppose that you have different regulations here as well. Let me talk about Europe, so I'm sure that I know what I'm talking about. Because when we are talking about drones and self-driving cars, you don't only have different moral problems, but you have different ways in which legal systems. I mentioned here America and Europe. Let's add Japan, how they can govern these fields of technological regulation. For example, in Europe, if we are interested in self-driving cars, those are the European regulations we have to amend. If we are talking about aircrafts, of course, sorry, these slides, I'll send you the slides, so please share the slides and you have all the time to check the regulations. But since time flies, so those are the European regulations for self-driving cars. But if we are interested on drones, we have a completely different legal picture. So as you can see, context dependency is a real issue. Of course, there are several good reasons why we are specialized. Even, well, we all work in law schools and we have colleagues, experts in criminal law, you know what I'm talking about. Still, we have the problem about this context dependency. Does this context dependence preclude a unified legal framework? In other words, we cannot talk about the fairness and the law. We should be obliged to talk only about fairness in criminal law, fairness in contracts and the like. I think we can put general principles and context dependency together. How is it possible? I think the key is given by the idea of governance. What do I think in terms of governance? First of all, we should distinguish three forms of legal regulation, namely top-down regulation. The lawmaker, the parliament, pass a law and you have the set of rules to be applied to legal society. Vice versa, we may think about bottom-up approaches, namely self-regulation. For example, here in Italy, the way in which commercials in television, advertisement in television is regulated is via self-regulation. And by the way, I'm a judge of this self-regulatory body, and it works. So, and there are, of course, several other cases in which we have self-regulation. So, top-down, bottom-up, and in the middle you have co-regulation, namely when lawmakers and stakeholders co-regulate, and more of this in few seconds. But here is the crucial point. In my view, it seems fair to consider that when we are dealing with the regulation of very complex technologies as artificial intelligence, both forms of top regulation and self-regulation are not good enough. Self-regulation, because we are talking about, in several cases, too risky issues to let the market decide by itself. On the other hand, however, when we have very complex technologies, it can be tricky. It can be delusional to think that the only problem is to invent a good set of rules and to apply them to civil society for several reasons. For example, the speed of technological innovation. Let me give you a very fun, sad example for the European lawmaker, but funny. In the early 2000s, 20 years ago, the European legislator passed a new directive for electronic money, but they think that the electronic money was traditional money in a new environment, and so they regulated money in a traditional way with a central bank, blah. What happened? 2 years later, a then young inventor from South Africa, Elon Musk, invented PayPal. So that the European directive, I'm exaggerating quite a bit, but just to give you, I'm Italian, with passion, the law was unuseful for technological reasons, so much so that the European lawmaker had to amend itself with a new directive. So, first problem with top-down approaches is the speed of technological innovation. The other big problem is that in many fields of AI, we are still looking for standards. Think about drones. Think about self-driving cars. Think about the healthcare system. And it's hard to develop standards without the industry and the market. You know what I mean? So for a number of reasons, at least in Europe, but not only in Europe, it's clear that top-down, bottom-up alone don't work. And we have to think about new ways to put together these things, namely co-regulation. And just to give you an example, and think about co-regulation as the interface, namely that which lies in between top-down. You have principles, fairness. You have bottom-up, namely the market, industry, research, working for, say, standards. And then we have to define that which lies in between top-down and bottom-up. And just to clarify this point, to visualize this point, let me give you the example of the European Data Protection Regulation. Why? For 3 reasons. First, it's well known, this regulation, because in Japan, how to put it, you agree that the GDPR standards are your standards, and we in Europe agree that the Japanese standards are our standards. It's reciprocity. Second, the GDPR is often considered as a very strong law, and so the impression is that this is simply top-down regulation. No, no, no. Third, have a look at Article 5 of the GDPR, which revolves around another principle, which is called the principle of accountability. And so let's visualize all this. Here you have. This is a model of co-regulation. Namely, you have the principles and rules. Have a look at the Article 5, the first section. You have the 6 set of principles. Fairness is one of these principles. Then you have finality principle, minimization, purpose limitation, blah, blah, blah. On the other hand, however, Article 5, Section 2 determines that it's up to data controllers, so it means the industry processing personal data, that it's up to them to determine, to decide, to define both the organizational measures and the technical measures, AI, in order to be compliant with the law. And then, so the accountability principle is this interface between what is arises from the top, the law of the legislator, and what comes from the bottom, namely self-organization of the market. That is, it's, in other words, in Europe, this is the idea. When you process personal data, this is a risky activity. And nobody knows about this risk better than who is processing the personal data. That's the reason why the lawmaker decides to let stakeholders, data controllers and data processors, to determine what security measures to take. However, this model cannot be transplanted in the field of artificial intelligence. Why? For a very good reason. We are still discussing about the principles of AI. So we are, in other words, whereas in the field of data protection, Europe could opt for this governance model. Why? Because we have more than 25 years of experience in the field of data protection. Alas, however, this is not the case of artificial intelligence because we are still discussing about the principles. This doesn't mean that until we don't agree on the principles, we cannot do nothing. What I'm suggesting with other colleagues and friends is an alternative model, which I called the middle out. As you can see, the idea remains the same, something in between top down and bottom up. Middle out, by the way, I didn't invent the formula. The formula comes from computer science. The idea, and if you check the articles of computer science, this is part of the interdisciplinary approach you mentioned. The idea is that you have to improve your technological system while the system still has to work. Let me give you my favorite example. As you can imagine, over the past 40 plus years, airport transportation, the world system, has been under the control of computers plus human assistants. But you can imagine that now and then these computers have to be upgraded. But you cannot say, hey, let's stop flying for 1 week till we upgrade our computer systems. So the middle out suggests how to improve a technological system while this technological system still has to work. You have to put together, again, in legal terms, the principles of the law and self-regulatory measures. And this is what we suggested. This is the second AI for People document, which we presented at the European Parliament in November 2019. As you can see, instead of principles, I suggest to think about no regret actions. What does it mean? It means that, of course, we have to go on discussing about the principles of artificial intelligence. But as I tell you before, this does not mean that until we don't agree on all the principles, we do nothing. No, there are several reasons. several things we can do together, because luckily we already agree in several cases about what principles should govern AI. For example, a human-centric AI, and, for example, a fair AI. On the other hand, instead of the principle of accountability, I suggest to think about coordination mechanisms in order to engage, depending on the context, engage the industry when we have to develop standards for self-driving cars, to engage the market when we have to develop standards for the healthcare system. The key is given by this idea of coordination mechanisms, of course, determined by the law, because those coordination mechanisms are the basis for any co-regulation. So I even suggest to think about this interface, this middle-out approach, according to these 5 features. First, the model has to be scalable, of course, both up and down, depending on your needs and depending on the specific AI application we are talking about. The model should be modular, namely decomposable. That is, by the way, I'm not inventing this. This idea of decomposability was advanced by a giant, Herbert Simon, who published in 1969 the first edition of The Sciences of Artificial. Nobel Prize, Herbert Simon was a great thinker. And in a way, the very idea of design as a science was promoted by Herbert Simon, and he insisted a lot on this modularity of every governance model. Of course, adaptability. The law has to be adaptable, dynamic. I was really impressed, I don't want to say shocked, but impressed when I learned about your Tokku in Japan, more or less starting 15 years ago. The idea is legal experimentalism. That is, and this Japanese approach, by the way, I already published, you know that my laws of robots have been translated into Japanese. There is a Japanese preface in which I thanks my fellow Japanese colleagues, because I learned a lot about this kind of regulation thanks to you. And the approach has to be reflexive, that is, matters of risk. And as I mentioned before, there is a problem with risk, and this is the reason why we have several Tokus now in the world. For example, we have a European Toku in Antwerp, Belgium, in order to develop standards, communication standards for drones. What's the problem here? The problem is that to determine a risk, you need data. What kind of data? On probability of events, consequences, and costs, in order to determine the level of risk. If you cannot determine the level of risk, you don't have insurance premiums, you don't have schemes of accountability. But we lack data. And that's the reason why several, starting with Japan, so chapeau, my best compliments, this pragmatic, reflexive approach has spread throughout the world. And of course, finally, the approach has to be technological savvy. That is, we hope lawmakers know what they aim to regulate. Otherwise, the final result would be the aforementioned European regulation on electronic money. You don't know what you are talking about, namely electronic money. It's very likely that your regulation either shall be amended several times in a very short amount of period, or it's going to be unuseful. So summing up, this is why, voila, I present my model as a smart model, smart meaning that the approach should be scalable, modular, adaptable, reflexive, and technological savvy. Okay, I have, let's say, 9 minutes. And so let me conclude this presentation. We have examined issues of fairness vis-a-vis legal principles. As I told you, fairness is one basic legal principle that should be examined in light of what's unique to artificial intelligence. I mentioned the fact that we already have several laws regulating AI. That doesn't not mean that those current laws are good, but we have them. And moreover, those laws are, as I told you, more often context dependent. So my problem was how to put together both things, and I propose a corresponding model of, I hope, good AI governance. We could further develop this model of legal governance. For example, this is a way to visualize what we propose as a model of legal governance for the web of data. More on this, there is a paper which is called the middle out approach. It's freely available online, and you can find more details about this idea in that paper, or we can discuss later during the question and answers time. Or, for example, another further development, as I told you, in the e-health sector. Namely, you can see we have the idea remains the same, and trust me, the first thing I told, I don't want to say the World Health Organization, but people of the World Health Organization, they should publish in few weeks the report on AI for health. And the first thing I stressed was, where are your coordination mechanisms? More on this when the report will be published. So for the time being, I cannot give you further details, but the architecture remains the same. How to put together fairness as a basic principle and the different context in which the idea applies, dealing with such technology as AI, which requires bottom-up approaches, standards. Well, the idea is this interface, the idea of a coordination mechanism. Of course, this is a work on progress, and that's the reason why all your comments, suggestions, remarks, and why not, critiques are warmly welcome. And that's the reason why I hope we'll now have a very fruitful discussion. Arigato.
Thank you very much. Thank you very much for your great lecture, Professor Pagallo. And next, I would like to make the comment of mine. So please watch the slide of mine. Thank you very much again, Professor Pagallo. I would like to make my comments and ask questions from a theoretical perspective of philosophy because my major is philosophy of law, and probably Professor Nishigai will ask from the technical perspective of technology and law, and Professor Mizushima probably from the perspective of political or social implication. Each of which they are brilliant expert, but I am a philosopher, so I want to talk something from the perspective of philosophy. And here I have two questions for you. And my first comment is about the significance of co-regulation model. Professor Pagallo locates this co-regulation model or middle-out model in between top-down model and bottom-up model, and regards it as complementing the shortcomings both of top-down and bottom-up models. It reminds me of the dialectic of Hegel. Is it not very accurate, probably, but I think it sounds like the Hegel theory. So, and this is the method of combining two conflicting models and pursue the better third alternative. On the other hand, the contrast of top-down model and bottom-up model reminds me of the contrast of artificial organization and spontaneous order by Friedrich Hayek, who is economic philosopher. And artificial organization is created by top-down method, and spontaneous order generated from the bottom-up human activities. Hayek points out the limit of human ability, the qualification or limit of human ability to design the society as a whole. And he insists that economic policies should not be carried out in top-down method, and he prefers the bottom-up method. And it means free market is better than planned economy. So probably the capitalist is better than the socialist, probably. And according to him, the same thing can be said about the legal regulation. Of course, he points out a lot of exceptions, but basically saying, rather than designing everything in the society, it will work much better when we use customs or conventions or traditions which have been accumulated in our society for a long time. So my question is that, isn't Professor Pagallo's trichotomy, so the three-part methodology, trichotomy, reduced to Hayekian dichotomy? So just consists of the top-down and the bottom-up, no middle-out. So such Hayekian dichotomy. So in another words, my question is, can't the merits, the advantages of co-regulation model or middle-out model be explained in the vocabulary of top-down model, or especially the bottom-up model? So Hayek thought in the context of the conflict between liberalism or liberal democracy and communism in the age of Cold War. If the context of the innovation of AI bring about a new model, so middle-out model or co-regulation model, there must be unique significance of the discussion of legal regulation of AI. So it is not the law of the horse, actually. And so, so my question is very simple. So please tell me the advantage of your trichotomy, so the three-part method. So this is my first question. And my second question is about context dependency. In my opinion, not only AI regulation, but also almost all legal regulations have context-dependent contents and context-dependent procedures. So it is very basic and general phenomena of legal regulation, in my opinion. So my question is that, doesn't this fact erode or violate the autonomy or independence of legal system? So here by system, I mean, so I have the social system theory of Niklas Luhmann in my mind. According to Luhmann, system maintains its own identity by drawing the boundaries between itself or inside itself and outer circumstances, whatever it is. System keeps its autonomy and independence by self-determining what to take from outer circumstances and what to reject from the circumstances. And here is a question about the relation between legal system and the technology system. The technology system is one of the outer circumstances of legal system. And legal system cannot keep its identity unless it reforms itself in accordance with the technological innovation. In this meaning, certainly, law is context dependent, so influenced by a lot of things. So, for example, Japanese legal regulation and European legal regulation is different because it is influenced by the Japanese culture or European culture. So in this case, culture is the outer circumstances for the legal system. So this is, I think, the feature of the context dependency. So, however, legal system may lose its autonomy unless it has the power of self-determination on how to reform or how to change itself. So the power of self-determination is necessary for legal system to keep its identity or its autonomy. So my question is that, does the progress of AI technology erode or violate the autonomy or independence of legal system or not? So probably you said something or a lot of things in your lecture, but please support or compliment to my question. So it would be great if I hear some opinion of Professor Pagallo about this point. Thank you so much. And this is all of my comments and questions. But do you want to reply each by each, or shall we finish all questions?
I would prefer each.
All right. So yeah.
Otherwise, I will need to talk again for
yes.
Straight to the point.
Yes.
First, thank you very much. Very precise questions. And let me start with Hayek. Since I work a lot on the legal philosophy of Hayek, by the way, there is a wonderful sentence in Law, Legislation and Liberty, in which Hayek talks about fairness. And he declares that it would be impossible to define what fair play is. We would say that cannot be computable and goes beyond what we can rationally manage. And so this very distinction by Hayek between cosmos and taxis,
Yes.
an evolutionary approach of the law and rationalism, it's a very strong perspective. How about my trichotomy vis-a-vis Hayek duality, yin and yang? First possibility, when Hayek talk about taxes, top-down laws, he's thinking about Western rationalism.
Yes.
The French philosopher Descartes and the like. Down to Niklas Luhmann, because in a way, this idea, Luhmann's idea on the autonomy and independence, he even talked about autopoiesis, drawing from work by the Chilean scholars Maturana and Varela.
Yes, Varela, yes.
If you adopt this strict rationalist Western tradition, I would say that my co-regulatory approach cannot be traced back to this rationalist Western tradition. Why? Because no rationalist, Hayek would talk about constructivism. This perspective would be incompatible with the very idea of a co-regulatory approach. If vice versa, but we are not following either Hayek or Luhmann any longer, if we adopt a milder, a soft, rationalist approach, then I don't have any problem to tell you, okay, co-regulation is part of the family of taxes. But it wouldn't be Hayek's taxes, it would be our taxes. So it's a problem of definitions, let's say so. Although, how to put it, I agree with the point, and luckily, I already stressed this point in an article. The title of this paper is Good on Life Governance, which is freely available on the internet. I published it in 2015, 6 years ago. And in a way, the long answer to your question is indeed in that paper. How about your second question about Niklas Luhmann? And how to interpret the autonomy of the law? Again, if we interpret this very idea in the strict sense of the Western rationalist tradition, I don't buy it, because there are several instances that show that the law cannot determine by itself the limits of its own domain. Why? Because I follow Hayek on this, and I take Hayek's ideas on cosmos seriously. So either you agree with Hayek's cosmos, and so you cannot follow Luhmann, or you follow Luhmann's ideas on strong legal autonomy, but then you cannot follow Hayek's cosmos. As they say in English, you cannot have the cake and eat it. Either you have the cake or you eat it, but not both. So in your slide, there was a point very interesting. You refer to technology as a circumstance of the law, which is coherent with a Luhmannian approach or coherent with Hayek's taxes. What I'm claiming is something very different. What I'm claiming is that technology is a regulatory system, much as the law is a regulatory system. Moreover, in addition to law and technology as regulatory system, we have further regulatory systems out there. Social norms, economy. So how to interpret the autonomy of the law in light of this multiplicity of regulatory systems? Well, in my view, we can reinterpret this good instance of legal autonomy in a way. When I was talking about law and ethics, that was the unsaid part of my presentation. I would propose you this definition of autonomy. What renders the law autonomous is the fact that at the end of the day, in terms of governance, is up to the law to strike the balance between technology, economy, social norms, etc. That is, between regulatory systems in competition. So, in my view, we can accept the idea of a legal autonomy, but not in the positivistic way Hayek's taxis, René Descartes, till Niklas Luhmann, but the autonomy in the sense that it's up to the law how to strike the balance between regulatory systems in competition. And a counter example was given before with the European regulation of electronic money. Technology is regulatory, and in that case, the law didn't win, technology won, for the reasons I mentioned before. So in this sense, but I have talked too much, I would accept your idea on legal autonomy, but reinterpret it as a matter of competition between regulatory systems.
Yeah, thank you very much. So so I learned that probably my questions and comments oversimplified the theory of Luhmann or Hayek, but actually yes, very very impressive reply. So thank you very much. So yes, so the next I want to move on to the next commentator, Professor Nishigai. So let me introduce Professor Nishigai briefly. Dr. Nishigai has master degree of information technology and the license of professional lawyer in Japan. And now he teaches criminal law in the law school of Chiba University. So he is expert of law and artificial intelligence. So Professor Nishigai, please go ahead. Nice to meet you.
Good evening, it's a pleasure.
Good evening. So now, I'm a criminal law researcher, but also actually I'm engaged in some kind of AI development or some kind of, how can I say, so to make some regimes of innovation and commercialization of AI development. You know, maybe GPEN. Yeah. So actually, after this after your lecture, so I will discuss, or I will attend the meeting about GPEN from Paris. Yeah. So
great. Thank you.
So, yeah. So now I'm very not from the perspective of criminal law, but from how can we collaborate with AI development. So I was very fascinated with your idea, a smart model.
So like making a computer program, so there is module based and adaptable and like object based, object oriented programming. So it is very fascinating. But so do you find some ways of people from different fields collaborating with each other? Because people from for example, so engineering or people from business or people from law, actually, we are very struggling with making conversation about AI or IP or something. So if you know, if you find some method for making a good conversation, good interaction with people from other different fields and different countries. So I'd like to I'd like to know that.
Excellent question. Excellent question. And how to put it? I can talk only about my personal experience, and so far I didn't develop a scientific method, if any can exist. What I can say is, yes, Professor Nishigai, you are right that when we are dealing with these issues, we need a multidisciplinary and even interdisciplinary approach, or as the then dean of the Santa Fe Institute in New Mexico used to say the no disciplinary approach. Maybe the no disciplinary approach is too much, but and my experience is, because we need people with different kinds of expertise, and I'll give you a couple of examples on this. We need to put together people from computer sciences, robotics, legal systems, and the like. Why say so? Because there are several cases in which the legal solution for a very tricky problem is given by computer sciences rather than the law. Let me give you a couple of examples. I mentioned the fair trial principle in criminal law and the fact that defendants ask for the code, the algorithm of the system which collected evidence against the client, okay? In many cases, it's reasonable that developers or the police cannot show you the algorithm, because that would mean that for every criminal investigation, you should invent a new algorithm, because you have to keep your algorithm secret for reasons of national security, intelligence, and the like. So, legal question, how to put together the principle of fairness with the rights of defendants and the secrecy, the protection of algorithms that for national security reasons you cannot show in a courtroom before the judge. This is a legal issue. The solution, in my view, is given by computer science. How? You can design, in certain cases, your IT system according with the no knowledge proof methodology of computer science, so that although I'm not showing you the entire code of my algorithm, I can prove you that my algorithm is abiding by the law. This is, or for example, in data protection, why Apple, I mean the Californian company, who collects every day more health data than, just to be sure, than the whole healthcare system in Italy on a daily basis, why Apple didn't have any data protection issue in Europe so far, although they are collecting our health data. Because they are using, again, for this legal problem, a technical solution, which is given by anonymization techniques via statistical methods. So the fact that time and again we have technical solutions for otherwise impossible legal issues suggests that we have to work together. However, as you said, when you put together in a table the computer scientist, the roboticist, the legal expert, the politician, you name it, it's hard to understand each other. My experience is that you need at least, if we are optimistic, 3 months, 6 months in order to start understanding each other. On top of that, you have to add the complexity, not about, I would say, computer science, more for soft sciences, ethics and the law. You have to add the complexity of different traditions, different cultures. And again, the best way to address this multiculturality is to work together. And in my experience, decades of international meetings, and that's the reason why I love Japan, but I like to travel to Japan so often, because there is no way to understand each other than working together. And that's the reason why, summing up, first, you are right. We need no disciplinary approaches when dealing with the new challenges of our world. This multidisciplinary, interdisciplinary approach requires a group of people work. If you pay attention to our AI for People papers, you have an example. We had some computer scientists, some experts of ethics, some lawyers, and so on. You have to have people working together, and after just a little bit, you start understanding the background of your colleagues. And the same applies for possible different legal cultures and the like. It's like swimming. How do I learn to swim? Swimming is, if you like Aristotelian ethics, how can I be a good man doing good actions? So how can we address the challenges of interdisciplinary collaboration, working together? I'm not saying that all problems solved, but this is the best methodology I've learned so far.
Thank you very much for encouraging me to continue swimming. Yeah, and so and listening to your story, so from the perspective of criminal law, so I one interest. I have one interesting question to you. So maybe your slides includes the challenge of AI, the AI for People paper of 2018. So number 4, eroding human self-determination. So maybe many people, many engineers are now focusing on maybe human supporting AI, I think. So, and this means, I think that humans feel they are supported by AI. Not how can I say, not so they don't think their own self-determination is influenced by AI. So, but actually, so not the central part, not in the central part of criminal law, but it is in Japan. It's very important for finding some child abuse cases. Child abuse cases mean just so how can I say so parents parents made injury to their own children. So
Mhm.
so and actually we have only some evidence about if we have only the evidence of the injury. So we have to think about whether the injury is made by child abuse or not. Just accident or just how can I say, fall down or something. So it's very actually now researchers, engineers are are doing research on automatically deciding whether the injury is created by the child abuse or not. So by using the data of the shape or size or some kind of some other characteristics of injuries, which was determined by in the previous courts cases. So, but I think so. It's very difficult because it is not guaranteed that the previous court cases were not unbiased, fair. So and I don't want to think that in that way, but some people how can I say this? It's very difficult to say. So it's inevitable to exist some biased judges or some biased prosecutors, I think. So maybe they are very easy to feel they were the AI or machine learning systems assistance eroding human self-determination because they are biased. So it is very dynamic. Maybe this question is very dynamic thing. So because AI can be dynamic, so AI can be biased or AI can be unbiased. But humans can also be biased or unbiased. So what is the criteria of the edges of eroding human self-determination or assisting human self-determination? What do you think about maybe in European people?
Well, the premise is that the more crucial decisions for our lives, finding a job, buying a car, admissions, loans from banks, several crucial issues in our lives are decided by computers. Let's use this formula. And nowadays by AI systems. And of course, we have a problem of bias concerning, well, never forget that there is no algorithm without bugs. This is an obvious truth of computer science, and it applies to AI systems as well. What to do? Well, in Europe, as you may know, in front of this scenario, the GDPR has introduced the so-called right to explanation. Namely, for whatever output of your computer system, your AI system, the GDPR has set up a right to first, a human intervention, and second, to an explanation of the output of that system. Of course, here you can say we are simply moving the problem, kicking the can down the road. That is, hey, but since many AI systems are black boxes, even the engineer, the group of engineers would find it difficult to reconstruct step by step how the AI system attained that solution, decision, outcome. What kind of right to an explanation could we have? This is a real issue. And again, I'm simply quoting you, Professor Nishigai, on the dynamics of both AI and the law, because it's a reciprocal tension or adaptation, in the sense that because of this legal regulation and the right to an explanation, a new field of technological research has developed, as you know, and it's called explainable AI. That is, in the same way in which, for example, the GDPR in Europe has established the right to be forgotten. But how to put together the right to be forgotten with blockchains? Again, a technology which by definition recalls everything, in the sense that you cannot erase from a blockchain a block of data. How to put together those instances? And here, what's happening is the fact that developers and engineers are designing their technological systems in order to comply with legal constraints. That's why we, so coming back, human self-determination, right to explanation, black boxes, in order to tackle the opacity of AI, black boxes, because of a new right to explanation, in order to protect human self-determination, engineers and computer scientists had to start working in something new, that is, okay, let's design explainable AI systems in the same way in which it's likely that some kinds of blockchains shall permit the erasure of some personal data. Otherwise, that blockchain would be illegal in the European jurisdiction. And this is exactly, in my view, the sort of dynamics you mentioned before law and technology.
Thank you very much. So I don't know the current situation of technological development because I'm still concerned about how to make explainable AI clearly complying with the legal system, because legal systems, law or statutes are usually abstract. So sorry.
But if I may, we can think about this problem in the following terms. Since we are already delegating cognitive tasks to machines, if you pay attention, almost all financial transactions every day are made by machines, not by humans. So the question, in my view, is how far the process of automation can go. How to draw the line between that which can be delegated to machines and that which shouldn't be delegated to machines, which bring us back to the problem of human self-determination. That is, when it makes sense, it's even good that machines decide for us, and when it's bad. In my view, the way to draw a line, is to think about the classical legal distinction, and Professor Takayuki knows about Herbert Hart distinction between plain cases and hard cases. When we have plain cases, no problem that an AI system takes a decision for us. Why? It's a plain case. If we have a hard case, and hard case means that even experts disagree on the legal solution for excellent reasons. A typical hard case is, can autonomous lethal weapons be lawful on the battlefield? Good reasons for saying no, never. Good reason for saying, well, if they abide by the Nuremberg Conventions. So in a nutshell, in the name of human self-determination, no machine should decide a legal hard case. This is my viewpoint.
Okay, okay. Yeah, yeah, yeah. I understand. Thank you very much. So now I'm researching on the technology and law every day. So I'm using this kind of term usually. So the co-evolution of technology and law. Thank you very much.
Excellent point. Thank you, Professor.
Thank you very much. The discussion about the easy case and hard case is so interesting for me. So, Professor Mizushima.
Hello.
Good evening, Professor.
Oh, thank you. Thank you for your presentation. As a political scientist, I'm also interested in your topic. But today, you propose the model of co-regulation model, and I think it's quite suggestive. As a political scientist, the term co-regulation reminds me of an important aspect of policy-making process in Western Europe, namely corporatism. Corporatism.
Yeah, got it.
Yeah. And corporatism is, probably as you know, is a governance system in which plural social organizations and experts join the process of policy making by discussing various themes. And by discussing and getting consent of the plural actors, in most cases, new policies were introduced or some other policies are introduced. And this kind of policy-making process, corporatism, was quite common in smaller democracies in Western Europe, namely the Netherlands, Denmark, or Sweden. But at some certain level, Italy or Germany, there was some kind of corporatism, I think. But however, it was quite common in the 20th century, but around the turn of the century, it was often said that in the time of globalization, quick response to the global challenge in the changing world, quick response, a swift action is necessary. So, for example, the concentration of power, making stronger of the executive power, it is desirable to tackle the new global challenge. And at that time, the corporatism, the participation of various stakeholders, social organizations or some experts, that was seen ineffective and outdated. And populist leaders, they gained power around the turn of the century. They argued that strong leadership is required to tackle global problems. So they thought that they themselves are strong leaders, like the leaders of the right-wing populist party in Italy. But in other West European countries, we saw the resurgence of populist leaders who say that they are strong leaders. Anyway, however, the reality is quite different. As was shown in the examples of many countries, without the cooperation of stakeholders, social organizations or experts, it is quite difficult to make real reform to tackle global changes. Only a strong leadership produced nothing, I think. Participation of social actors even promotes effective and innovative policy proposals because by participation of various actors, you can get more information and more ideas. So I think in that sense, your model of co-regulation or a co-determination model, it is quite important, and we are living in the world where we need inclusive approach both in the field of AI and other policy fields. I think so. As a political science, I agree with what you argued. Thank you very much.
Thank you, Professor Mishima. And I confess, I didn't think about the possible connection between co-regulation and corporativism. Thanks for the warning. Because, and there is a reason why I didn't link the dots. I didn't make this connection because talking about backgrounds and different political traditions, corporativism in Europe, not to talk about in Italy, is linked to the idea of the state as an organism within which you'll find stakeholders, the market, the industries, but all within the framework of this Hegelian state, just to quote an author which we previously mentioned. Not to talk about the fact that the corporativism in Europe has been linked also, but not only, to the idea of a planned economy, not the idea of a market. So from a political science theory, I would say that co-regulation and corporativism refer to two different, really different ways to think about politics and main actors, the state, the market, and the like. So much so that when I was discussing about technology as a normative system, no corporativism would accept what I said before, that is the competition between normative systems. A corporativist would say, no, it's the state who should harmonize these normative systems. On the other hand, you stress another very important point, namely my, let's call it, model of co-regulation can be interpreted, understood, either as a descriptive tool, namely, I can show you that regardless of my opinion, Europe, I mean the European Union, has adopted this co-regulatory model, not only with the GDPR, but with, for example, if you have a look at the very recent Digital Governance Act of the European Commission, 2 months old, you will see that, again, the European lawmaker has adopted this co-regulatory approach. And so the model has a descriptive power. Then, of course, you have my opinion, and this is the normative side of the story, the reasons why I think it's good to adopt this model. But then we have the third issue you stressed, which is another very important point. How about global challenges? Can we think about a co-regulatory approach for the world? Listen, of course, global challenges need global answers, and the pandemic is, sadly, but it's a good example of this truism. However, talking about artificial intelligence now, however, we know about the difficulties we would have starting dealing with the global challenges of AI at the international level of the United Nations. It would be nice to have this international legal framework common for all the world just to tackle the global challenges of AI. But, you know, I'm Italian. I'm from the country of Machiavelli. So I'm a realist, also because I'm a lawyer. So I'm try to be, you know, the famous painting, Plato showing up and Aristotle showing down, the sky and the earth. Here, Aristotle. As lawyers, we have to be practical. And waiting for this global answer, I think that it's more realistic to expect uniformity first at the regional level, macro regions. So it's likely that, as occurred with data protection, we had the European regulation, we have the crazy American model, we have Japan, then we have the agreement, the 2019 agreement between Japan and Europe. I think that lest we talk about war, in which, as I said before, we have already a group of governmental experts of all the important countries in Geneva. Otherwise, if we are discussing about civil and not military artificial intelligence, we should expect first uniformity at the regional level, and then, if we are lucky, scaling up until we reach international agreement under the United Nations. But for the moment being, what we should aim at is, of course, we can do both things at the same time. That is defining what the governance of artificial intelligence is at this macro level, and start working on international cooperation. Again, the law, and it was stressed before, this is not the first time that we discovered that the law is context dependent. It has been context dependent before AI and after AI. Still, many problems regarding the global challenges of AI and the like depend on the kind of applications of artificial intelligence we are talking about. For example, if we are talking about AI in civil aviation transportation, we already have an international framework. We have the Chicago Convention, we have ICAO powers. So we already have an international framework for the global challenges of AI in civil transportation systems. So it's really a complex topic, And I'm afraid that we don't have the magic bullet. We don't have the one-size-fits-all solution. But at least we have a model, up to you whether descriptive or normative or both, in order to start understanding first the complexity of the topic, and second how to tackle this complexity. But thanks, your questions were very, very interesting.
Thank you very much.
Arigato. Thank you.
Okay.
Thank you very much. So we have few minutes left, but actually I came up with another question, so very briefly. So you mentioned to the rationalism in the Western civilization when you explaining the Hayekian taxis, and so many people say Western European civilization belongs to the rationalism, and Japan as Asians are not. But I think it is oversimplified, too easy way to explain. So I think, or I guess, Europe is not so homogeneous. So my question is, do Italy have any difference from other countries such as Germany or France or any of other European countries about the rationalism on legal regulation? For example, Italy is very rationalistic and France is not, or kind of that. So please tell me if you know something about the difference inside Europe.
Wow. I agree with you that we should prevent oversimplifications in the sense that, of course, rationalism in the legal domain, Thomas Hobbes, so contractualism, is a typical Western philosophical posture, but it would be an oversimplification to think that we had only European rationalism in Europe over the past centuries. Why I say so? Well, for example, one of my favorite philosophers, we didn't mention him, but he's the grandfather of our field, and his name is Leibniz. Of course, Leibniz was a rationalist, but at the same time, if you have a look at his legal and political thought, he was a traditionalist. And I'm talking about the grandfather of legal informatics, the grandfather of AI and law. But in more general terms, I mean, in philosophical terms, how about romanticism in Europe? How about idealism and your beloved, our beloved Hegel? What I see, just to quote Hegel, is rather a dialectics between rationalism, romanticism, or evolutionarism and constructivism, so that, of course, the winner, or at least it seems so for many decades, looks the rationalist posture. But first, it would be a mistake to forget all the non-rationalist movements, very important, that we have had in Europe. You asked about Italy. Well, in Italy, we have a century ago historism. I first quoted Benedetto Croce, and Benedetto Croce was an idealist, whatever you want, but not rationalist. in the same way in which it would be a terrible mistake or to say we Europeans are individualistic and you are communitarian. Yes and no, because of course it sheds light on some peculiarities, but we would forget, talking about Western European individualism, that especially here in Italy, we have a very strong sense of the family. And so, as usual, these generalizations help if they are used as it occurs with medicals and drugs. If you use just a little bit of that product is good for your health, too much. And so these generalizations are helpful to introduce a debate, not to kill it. So again, we are on the same page, Takayuki.
Yeah, thank you. Thank you very much. And any other questions? No? No. Okay. So thank you very much. It's about the time to finish. So I'd like to make some final remarks. Thank you so much, Professor Pagallo. I enjoyed very much for the great discussion. And actually, 3 years ago, 2.5 years ago, I met Professor Pagallo in a conference hosted by Professor Christoph Lütoge in Technical University of Munich, titled Business Ethics and Digitization. And I was so impressed by the presentation of Professor Pagallo at that time. And now I am pleased very much with our continuing discussion today. So I hope we can be going on this way and deepen the relationship between us and between Turin University and Chiba University. So please keep in touch with us. So let me close this conference. Thank you very much. Thank you.
Thank you.
Thank you very much.
Thank you, guys.
Thank you. See you.
Has been a pleasure.
Next time in Chiba.
Cheers.
Yes, next time in Chiba. Thank you. See you.
Yes.